the chair of the Fairfield Board of Assessment Appeals. Today is Monday, April the 19th. The time is 6:41, and this is a meeting to discuss with the town attorney, have a discussion with the town attorney regarding the process and procedures, and also deliberate and vote upon appeals properly brought before the board, and I'm calling this meeting to order. So I have added an agenda item to our scheduled meeting today, and I've invited.
I'm sorry, Harold, can you just call the roll first, or I can call the roll? Call attendance.
Yes, if you'd like to do that, and then I will introduce Jim. Okay,
sounds good. So I don't have an agenda. Well, I should know who's on here by now, so I'll go through who's here. Harold Zawadzki.
Here.
Peter Rupert. Alexis Harrison. Alexis, I think she was there.
I am here. Thank you.
Okay. Paulette Kuzo.
Here.
Ronique Patel. Not here. John Spolier. Not here. Judy Zablak. Not here.
And Catherine Giff.
And Catherine Giff.
Not here.
Not here. Okay.
All right. I'll continue with my introduction. Then I have added an agenda item to our scheduled meeting today. I've invited Jim Baldwin, our town attorney, to speak with us. There's been some confusion and questions lately regarding the rules under which the BAA is obliged to operate. And as some of you may remember, last December during our organizational meeting, the board did review code of conduct and regulations regarding FOI rules as they apply to our board. And I felt it would be beneficial to have Jim review with us once again the FOI rules, code of conduct, and the role of the Ethics Commission as they pertain to our board, and also answer any questions, general questions that we may have. So Jim, I'm going to hand it off to you to assist us in better understanding our obligations under these items.
Okay, thank you, Harold. If I can call you Harold and not be so formal, but
yes, please.
Mr. Chairman, I'm happy to be here. I want to start off by saying how this Board of Assessment Appeals period has been like no other, without a doubt. You're facing challenges of not only a revaluation year, but on top of that, you're dealing with a pandemic and doing things like we are now via WebEx meetings. And it's all very, very new and different for not just this body, but also other bodies in town. So it takes some getting used to. And while I'm not super familiar with the workings of the BAA in the past, I think I'm familiar enough to know that this is very much so radically different from how those meetings have been held in the past. And so that makes it very challenging. The meetings that we're at now, of course, due to the pandemic and the governor's executive orders, are all being recorded verbatim. That's something that never happened in the history of the BAA, to my knowledge. Not Robert's Rules of Order, but the Freedom of Information Act, the FOI. FOI Act only requires that minutes be taken, and that the essentials of decisions and deliberations be included in those minutes. But it's really very different from what you're experiencing now. That's not to say that those minutes that you produce today need to be any more detailed than they were in the past. But again, it's very different for these hearings to be recorded. And that may make it difficult, and it may add some additional kind of burdens or things that feel like they're burdens to members because of that being the case. I want to remind members that your decisions here are appealable, and they're appealable in a de novo proceeding. And I just want to take a second to explain the significance of that. A de novo proceeding means that it's from anew, it's from the beginning. You restart it. So what you're doing and saying here is not, for the most part, something which is going to be scrutinized and reviewed, every single word, every single statement, every single rationale that may be provided in your deliberations for a reason to allow an appeal or deny an appeal, or to make a reduction or not make a reduction. So I want you to take that to heart, because it may take a little pressure off of your deliberations here, knowing that. I want to also remind the board members that you're elected, and you're elected as individuals, and your decision is yours to make, and it's based on everything that you know about a particular appeal. It's based on your world life experience to some extent. It's based on the questions that you ask and that are answered by the applicant or by the tax assessor or by Mr. Fazio and his company. You may have life experiences in real estate that assist you in making those decisions, and I don't think that there's anything untoward about that. With that being said, it is your decision, and your rationale is your rationale, and it's perfectly appropriate for members of this body to explain their rationale or their thinking on a particular property to other board members. However, it is not appropriate to attack the motives of the speaker. It is anathema to the process and procedures that are what is Robert's Rules of Order that should be followed for the most part, and decorum and civility in your deliberations and considerations is essential to a smooth process, and one which is ultimately going to bear the best results. And it's just it's Robert's Rules of Order were created for the very reason that one should address the issues and not the person, or the thoughts and opinions, but not the motives of the speaker. And I think that based on some of what I've reviewed, I think that it can be said that perhaps that line was crossed on a few occasions. And I'm not here to speak to any individual member. I'm here to give you an overview and a reminder of the importance of that fundamental rule of decorum in your proceedings. It's absolutely essential. Let's see. To that extent, I think it's important for people to understand that while some meetings can be held sort of loosely, and more conversational, perhaps, and I haven't really sat in or listened to your meetings, quite frankly, but perhaps it would be better for you to be more strict in your following those rules, which say, for example, that you go through the chairman if you want. Mr. Chairman, that's up to you. But certainly, Harold, you are in charge of the proceedings, and every member here should recognize that. Every member here should recognize that Harold is really the one who should be calling upon members who want to speak, and giving those members an opportunity to speak, and to argue over somebody or to speak over somebody is again anathema to the form in Robert's rules. So I urge you, not knowing any particulars in that regard, but I just urge the board members to take that to heart, as well as what I said earlier. If something is considered to be crossing the line, Harold has the authority to call that statement or person who's making it out of order as not germane to the topic at hand. If, for example, it is questioning the motives of another member or something else which is inappropriate. Let's see. I was asked about. I've got notes here that I took. The code of ethics has come up, and I just want to tell everyone that the code of ethics is presented in the town charter is one which is very much up to the individual. And every member here, as an elected person, and really a town officer, is obligated to be cognizant of those fundamental rules, which is if you have any direct conflict, your personal relationship with an applicant or a business or any sort of a financial connection, you would be wise to recuse yourself from a particular application. And so with that being said, it is not for other board members to question the integrity of another board member. Again, that goes to the question of attacking the person and not the idea or the thought, and that is, again, inappropriate. It is up to each individual board member here to decide on their own, in their heart, whether or not they would be better off recusing themselves for any reason whatsoever that might lead to the speculation or belief that someone has a conflict of interest. The Ethics Commission, to that point, if that's not to say that people can't file an ethics charge against someone, but that process in itself is one which is supposed to be done very quietly, not publicly. It's against the charter to make public accusations of someone breaching the code of ethics, and that's something which would be presented to the Ethics Commission for their review and consideration. They would look at the complaint, and if they do a little investigation, and if they find that there is probable cause, then they can schedule a full hearing. But until the Ethics Commission files or announces that they're going to have a full hearing, the complaint itself should be anonymous. It shouldn't be blasted all about town and shared with other people, because it's a very, very serious charge, and it is a violation of the code of ethics itself to do otherwise. So it should be done anonymously, and you should take it very seriously if you're looking at filing any such charges. Otherwise, it is up to the individual board members to address any questions of whether there's a conflict of interest. And please, if anybody has any questions while I'm rambling on here, by all means, let me know. Raise your hand, or however you do it here in your meetings.
Oh, this is Harold. I do have a question, and that is, would you say that the Roberts Rules encompasses standards of conduct? And how do standards of conduct relate to the code of ethics? Is it a subset of that, or are they mingled together?
Standards of conduct in a meeting? I need to understand what context you mean standards of conduct.
Well, I've seen the term standards of conduct used in some of the things that I've read, and I was wondering if standards of conduct is encompassed within Robert's rules. Is that a way to see it? And is there, how does standard of conduct compare with code of ethics? I mean, is code of ethics there to support standard of conduct? Could you say that?
They may overlap somewhat, but I believe that the code of ethics really speaks to a much more serious breach of ethics than
Okay.
someone being unruly at a meeting. I mean, it could rise to that level, but gosh, I hope that's not the case. And it's not for me to speak for the Ethics Commission. That is something that ultimately would go to the Ethics Commission. And if there are any particular examples, I think that's a situation where one would reach out to the commission that meets very rarely in our town, fortunately. In some cases, they haven't met for years. But that's something that you would present to the commission for them to opine on. And I'm sure they would welcome it. But again, that's something that is done relatively well. It's anonymous, it's not anonymous, but it's not shared with the rest of the class or others. It's something that if an individual member believes that something should be brought to the attention of the Ethics Commission, then that's your belief, and you present it to them. But you do so individually on your own and not as a group, and certainly not done in public.
Thank you. Another topic that I'd like to ask you to review is how emails are affected by or FOI rules. How emails that are shared within the board or board members are supposed to be FOIable.
Yes. Well, let's talk about meetings. Your meetings and deliberations are to be public, and an email chain that includes every member or a majority, and in some rulings of the FOI Commission, it doesn't even have to be a majority. But the point is that deliberations and opinions should not be shared by the board on matters of substance through email. You can ask questions to everybody about their availability for a meeting, which is non-substantive, but to address an issue which is before the board, that the board's going to decide that it's an agenda item, is inappropriate, and it is a definite violation of the Freedom of Information Act. Yeah.
Thank you.
And in terms of FOI rules in general, it's very broad. The rules that allow for anyone to ask the town to produce emails addressing matters which are before a board or commission. So all the more reason why one should be very careful about disseminating emails that address those substantive issues that are before the board as a whole. That being said, you are not precluded from speaking with other board members outside. You're not precluded from having a phone call with somebody. That's not an FOI violation. That is allowed, but there's a gray area where it crosses the line, and where that discussion should really be held in the meeting proper. As a rule of thumb, it would probably be best for members just to keep their thoughts and remarks at a meeting, but I can't say that it's wrong to share an opinion or to reach out to another board member on a particular topic. It's not prohibited by the Freedom of Information Act.
Thank you. I see Paulette is raising her hand. Paulette?
Yes, thank you. I had a twofold question, really. So when an email is addressed to the entire board, I'm assuming that that means everybody who was an elected board member would be in that email. Now, what happens if that email chain happens to include somebody who's not one of those elected members? Is that considered sharing it with the public? And so does that create a problem if that were to happen, that if we shared it with one person or two people from the public, does that mean that we're discriminating and we should have to share it with everyone?
Well, no, Paulette, I'm glad you asked that question, because what I want to emphasize is that you should never have an email to all board members addressing an appeal. It is a violation in and of itself to do that.
I understand that. I guess I was
Okay.
asking more from the perspective of the board. It's a group email, okay, for the board members. What if people that are in that email chain are not elected members of the board? Should they be in that chain? And if they were included and received emails that was intended for only the board members, no matter what the email was, what now? We've shared it with someone outside of the board. Is that a problem?
No, I think it makes a difference. I'm not sure if I'm completely understanding it. So let's talk about this. So is the email generated by a board member?
Yes.
Well, that simply should not happen. So to say that other people from the public were included in the email chain is not really germane. The problem lies in the fact that somebody, not saying you, but that person has violated the Freedom of Information Act by addressing matters which are for this board to consider outside of a scheduled hearing, outside of these meetings that you're holding. So that, just stop right there. That's where the wrong has occurred, and it makes no difference whether or not that person included members of the public. It may be putting gas on the fire, but the fire is already blazing in terms of it being just flat out a wrong thing to do.
Okay. So what if the content of the email wasn't addressing a specific appeal or a matter before the board? It was addressing perhaps behavior that occurred during the meeting or how somebody felt about that behavior.
Yeah, I think that we dovetail into questions of decorum, because as I said earlier, one should not be addressing the motives of somebody in a meeting, and it's just not appropriate to address someone's behavior. And I think that it's wrong on many fronts to put something out which might paint another board member in a negative light, not just sharing that with other board members, which I think is wrong, but also to disseminate it to the public. I think that makes it probably worse.
So if you have,
If I may just touch on something else you suggested, if you're talking about a broad topic, like a general area of concern for you or for whoever it is that's sending out the email, again, that's a topic which really may be substantive. It sounds like it might be if it's a general principle in an individual's approach to how they're viewing appeals. I think that's a matter which should be, if you're going to, and again, not you, Paulette, but anybody, if that person is going to share that opinion, their view of appeals generally, I don't think that that's wrong, but I do think it's wrong to do it in an email. I think that's a topic which should be a subject that would be discussed among the board members at a meeting if it's germane to your deliberations. And it may be, because I don't know the exact example, but in an ideal world, you're making decisions, and you should be making decisions on a case by case basis. But I can imagine where there are some instances, perhaps where members have a kind of a broader view of categories, whether it's commercial, I don't know, but maybe that would be germane. But again, that would be something for the chairman to either allow or to consider it to be out of order. And any member can ask for a point of order with the chairman to that effect. It's not just up to Harold, but it's if somebody thinks that something is not germane to the conversation, it could be brought up to the chair, through the chair, and Harold can then rule on whether or not he would allow that topic to be continued, or whether he thought it was out of order.
And then just the last thing then, if you had, let's say you thought that there was a reason to go to the ethics committee for something, say it was for a conflict of interest, and it was continual. How long did it take them to do anything about it? Because we have a short window in our group. So if somebody were really concerned, if there was evidence that there was some activity that was a definite conflict of interest, and you took it to the ethics commission, would it be corrected in time before we finish? Otherwise, the problem continues to go on, because we only do this really for a month usually.
Yeah, I think the answer to your question is best addressed by the chair of the ethics commission, but I am, it's a very small group, and based on the situation as you described it, I think that you would get a fairly quick turnaround from them. But I can't speak to them or for them, but I think that would be the case. And again, it goes back to ultimately it's a sanction that is oftentimes after the case, after something's been presented, or after something has happened. It's not necessarily going to stop deliberations. It's not necessarily going to thwart somebody from committing unethical behavior, but it's on the tail end of that where the sanctions are imposed, and I'm sure nobody on this board, nobody in town wishes to experience something like that. So that should be a prophylactic effect in and of itself. But it's not something that should be used as in order to further one's opinion on a particular property or topic. It's a different area that would be addressed. And I offer my services to anybody individually. If you want to call me, email me and ask me pointed questions, I would be more than happy to share with you my opinion. And of course, it's only that, but I have some experience in the area and with the Ethics Commission, and certainly I could help facilitate maybe a timely response from the board, that is the Ethics Commission rather. But yeah, I would urge you to pick up the phone, whoever, if anyone has questions about that. I'd be happy to talk in more detail. But again, I don't think it's an appropriate topic for us to discuss detailed situations in this meeting. It's just simply inappropriate according to the rules of ethics that we have in the charter. I hope that makes sense.
Actually, it was a very good description, and I understand what you're saying. I'm not happy about it, and I might not agree with it, but if that's the rule, that's the rule. I come from a place when there's an issue, it's discussed and it's over with and we move on. Letting it
I-
fester, not a good idea.
Yeah, I understand and appreciate that. The Robert's Rules of Order and the rules by the Ethics Commission and our town charter are designed in such a way, and it's for very good reason. A lot of thought has been given to it, and it's not always satisfying to have to follow those rules, but it's very important that they are followed. So I would urge anyone again to approach me or go right to the chair of the Ethics Commission, if you care to do so.
Thank you.
You're welcome.
This is Harold. Are there any other questions for our town attorney, Mr. Baldwin? Kathleen?
Jim, there was just, we've had some discussions on our board, and perhaps disagreement on the role of the assessor in our process. So can you speak to the role of, town department people and us, or Phasio, the consultants, where do they and don't they fit with our board? And one way or the other, I just think it would be good to hear your opinion on that, because I don't think we're all on the same page, and that's one thing
Sure.
I have to say.
I'd be happy to address that. Well, what's being appealed essentially are the opinions of Mr. Fazio and Mr. Murray and anyone else in that office. And so I think it only makes sense for questions to be asked of them and for them to explain their rationale for any particular evaluation. I don't think that there's anything wrong with that. Ultimately, it is your decision individually, and then when you take a vote as a board as to what to do. And I go back to what I said in the very beginning, and that is that thankfully you're not creating a record which is going to be scrutinized and reviewed by a court word for word. Everything that you're saying, it's going to be this de novo appeal, which is going to be based on other facts and appraisals and whatever else it takes to have an appeal and to prosecute an appeal in the Superior Court. So it's your individual decision ultimately. You're voted to this body by the townspeople, and you have a right to your opinion, but so do your other board members. Certainly, if some board members want to hear the analysis and opinion, rationale of the assessor or the assessment company, that's perfectly appropriate.
Paulette, did you have your hand up?
Yes, I just wanted to expand or extend that question. I personally I think it's great that the assessor is involved with, when he can help us with things that we don't understand, perhaps clear up some facts that don't always come forward in the appeal. However, I am one of the people who thinks that it is not a good idea that the assessor be at every meeting and involved in the actual goings on of the meeting. It's a board of elected people by the townspeople. And I know that the townspeople do not want him deliberating with us, and I don't blame them. I don't either. Everybody gets a chance to present their side. When we need clarification, we ask for clarification. But to have an assessor or anybody else who's a town employee sitting there debating and deliberating and offering information and butting in when we're trying to deliberate facts, I don't really think is appropriate. That part isn't appropriate. I certainly agree that having him there as an extra person if we need help, as an expert in something that we need clarified, yes, but certainly not, come on and join the party. Let's all work together. That's not what it's supposed to be about. I've been on the board before, and that was never the way it was. I don't know where this idea came from that the assessor should be at every meeting. And parts, that's the part that I object to.
Okay, well, I think that's a valid point. And to what extent Mr. Murray or Mr. Fazio participates, I think is ultimately up to the chairman, but it is a subject which I think everybody should be sensitive to. It is for the applicant to justify their appeal, and if there are questions about that a board member wants to ask of the assessor, or Mr. Fazio or anyone else involved in that process, I think it's appropriate. But to what extent Mr. Murray or Mr. Fazio unilaterally express their opinion without being asked, then that may be somewhat in the gray area, and I would be careful about it as a board. I think that there is a line there that can't be crossed. To your point, Paulette.
Thank you.
So just as a follow-up question to that, Jim, so say Paulette felt that Ross was giving his opinion or something like that, how would she address that appropriately with the chair? Would she say point of order, or what would be the Robert's Rules of way of saying, I don't agree with, I feel like this is over the line?
Well, I think that technically speaking, he should be asked to participate and not unilaterally participate unless he's been asked to do so by a member.
But if it happens, I'm just saying if it happens or whatever, because sometimes people feel that it's over the line. So is out asking the chair saying, point of order, is that the correct way to bring it to the chair's attention?
Yes.
Okay.
Again, I'm not here to. I guess we have to talk turkey when we're talking about the assessor. We all know who he is, and yes, if Ross, you're listening, I don't think, I think that the line is being crossed if he's not asked to present or participate, but rather unilaterally jumps into your discussions because he's not actually a member, but he is an integral part of the assessment process, and therefore that's why I say it's okay for him to be there and to be relied upon for his opinions when it's asked of him.
Right. So it happens, right? So I would just say that the person would say, Mr. Chairman, point of order. I believe the assessor's, speaking and when he wasn't spoken to, and then Harold would rule on that. Is that how it goes? So that it's, so it doesn't get heated and, personal, right?
That's correct, Kathleen.
That's how it goes. Okay.
And then any other board member could say to that, in that part of the discussion, I would like to hear from Mr. Murray. And in that case, I think it's okay. But yeah, as you described it, that would be the appropriate thing to do.
Yeah, this is Paulette, you have another comment?
I'm trying to contain myself like I promised I would, Harold, but I'm starting to get annoyed. So I can say I don't like it the proper way that you described, and then somebody else can say, well, I think it is, and so here we go. So we might as well just let him be involved in every decision. Why not? Why waste time? And actually, this business of Mr. Chairman, may I? This Robert's Rules thing really doesn't work for us. Is there a different kind of procedure we could follow that's a little bit smoother, a little bit easier, takes a little less time? Something called like the modern rules of order, where maybe things could be done a little bit differently so that it works better for the group?
I think that is your latter question. Your second question is up to the chair, but you default to Robert's Rules of Order for good reason, and it's to maintain a level of civility and decorum among the body during your deliberations.
This is Harold. I don't want to spend too much more time on this. I want to respect Mr. Baldwin's time, and also we do have appeals to review and deliberate and vote on. Our charter is this wide. Our charter is very narrow. We hear, deliberate, and vote on appeals that are brought before our board. We have challenges to complete our duties in a specific time frame, and we do have the assessor present in our meetings because, as you pointed out, Paulette, we oftentimes need to get information from the assessor. So I cannot determine ahead of time which meetings he should attend and which meetings he shouldn't attend. And we do ask him questions, all of us do, and we get appropriate answers to help us with our opinions and to make our decisions, and we vote on our opinions. So I do believe that it's beneficial for the board to have the assessor on hand for us to assist us when we need his assistance, and we do so often. Our range of responsibility is this wide. Our main focus is to deliberate, at this point, deliberate and decide and vote upon the appeals that are brought before us. And we vote our opinions, and that's how we express our opinions. During the deliberations, we can discuss the ideas and the information that's brought before us, but we are voting our opinions. That's how our opinions gets recorded. So unless there's any other questions, I want to thank Mr. Baldwin for giving us of his time. I think that going forward from this point on, we are all more aware of the rules and response that we are guided by and the responsibilities that we have in terms of our ethical duties and how we should operate to be as efficient and productive as we can be. So again, I thank you, and I thank everybody who participated in this discussion.
Harold, if there are no other questions, I just want to end with two things. And first is, if anyone does have specific questions or situations that they think are not appropriate based on these discussions tonight, to be aired by the full board, whatever the subject matter, I'm happy to speak to that board member and in confidence. And also, I'd just like to end by saying I thank everybody here, because I know that this is just a huge task that you're all tackling on behalf of the town. And your volunteers, yes, you're elected, but nevertheless, it's a very, very important function. And myself and the administration thank you all for your efforts, and we wish you the best of luck.
Thank you, Jim.
Thank you.
Thank you.
Good night.
Good night. Okay, moving to the next item on our agenda. I'd like to see if we can start doing some of the properties that were on our list. Alexis, have you prepared some of your appeals for us today?
Yeah. Yep.
Great.
Give me a minute just to gather some things, if you don't mind. Sorry, I have a lot of windows open at the moment, so just bear with me.
Okay.
Okay, so we are in the beach area. So I'd like to, if it's okay, I will go a little out of order just based on what I have prepared for this evening.
That's fine.
Okay, great. So we will go to appeal number 386, and that is 869 Fairfield Beach Road. The owner is Jane Purcell. So I would.
That appeal number, I missed it.
Oh, sure. It's 386.
Okay, thank you.
And hopefully everybody can hear me. Yes? I just got an internet booster. Good. Okay. So I would like to make a motion for discussion to bring the value, the appellant's opinion of fair market value from 4 million. These are bigger numbers than we've been having. 4,024,400 to the appellant's opinion of fair market value to 3.5 million to the range of 3.6 million.
This is Harold. I'll second it.
Great, thank you. So if you clicked in the packet or this important documentation that the appellant filed, she gave 2 analysis basically of the closest of the comparisons. And again, she provides some insight that, she and her husband have been living at the home in the beach area for many years. I believe this is their second property in the beach area now. They live now on the beach side of Fairfield Beach Road. And she just noted in my conversation with her that she's really kept abreast of the real estate market in the area. So I will continue. So they've attempted to provide, two analysis that they believe is fair. And you can see the supporting tables 1 and 2. So one approach looks at the homes which they believe are the closest comparables to their home. And then she noted while there are 200 waterfront homes on Fairfield Beach Road west of Penfield Beach, they believe these 11 homes in this area closely resemble their property. It's obviously a very nice home. And then the second approach that they took is an analysis of all the waterfront home sales on Fairfield Beach Road since August of 2020. In this approach, as she states, she simply takes the average sale price per square foot for all homes recently sold in that time period and compares it to the estimated market value that has been assigned to her home. I don't know if it's easier for me to go through this table or if you guys want to take a moment just to review it. And then we can maybe have a discussion.
So this is Harold. When you say that she,
Out of here.
I have a question.
Sure.
You say that there was 2 methods that she deployed to come up with a value. One was based upon the square footage of the homes that she listed, and the other is the land values of the homes that she's listed, right?
Correct.
Okay. So I think
I think it's
That's
actually
good.
more total livable square footage, I think, versus land value. I mean, she has the land value in this table too.
right. Well, the property value
That's-
is
that's
the combination of both, obviously.
Right.
So this is Harold again. I see the land value covers a broad range from 967 square foot to 324, $329 a square foot to come up with the 645 average. And
I mean, based, I think, on these numbers, I mean, I think her ask it seems reasonable to me, but I would love to hear input from others who may have differing opinions.
So this is Kathleen. So I'm just looking at, she's got a few sales listed there, right? Because often we don't do the square footage per, averages and those kinds of things because we know that things are on a curve. So she also has a creek property, right? So
That's the, are you referencing the other property that she's appealing?
yeah, her second appeal, because
But I don't think that incorporates this appeal though, right?
well, that's what I'm trying to figure out. When she lists the sales, often the sales prices of properties that have a creek side and a beach side, the sale price will include both of the lots together. So without looking at 891, 831, 901, all of those, I don't know if those sale prices include.
Well, they're 2 separate properties from what she told me, so I don't know how that
Yeah,
would.
I know it.
This one, and maybe the assessor, if he's still on, could offer us some insights on that, so we don't have to guess. So is the question, Kathleen, for Ross, are they 2 separate deeds? Are they 2, is the Creekside property contribute to the sale price of the beachside property?
Yeah, so in other words, she's listing some sale prices there, right? And that's the square footage of just the home, or it must be the square footage of the home, right? So like,
I'll pull up the field card.
Yeah, 1641 Fairfield Beach Road sold for 3.2 million, it's 4,800 square feet. So she's dividing out the price per square foot of just the house, right? And that's
and again, I did ask Mr. Murray if he could offer any insights on that.
Yeah.
I'm not sure if he's still on. Did he leave?
No, I'm here. And just rephrase that question for me. I wasn't quite following what you're looking for.
Okay, yeah, so the applicant, Jean Purcell, she, owns the house at 869, and then she owns the other property at, what is it, 860? And that's on the creek side. Looks like a very small piece of land that can't be developed. I guess the question is, what I guess was the sale of that, or the assessed price of that property included in the price of her home? Is that right, Kathleen? I don't want to misquote you.
This is Kathleen. It's actually the other way around. It's the
Oh, sorry.
She's using some comps, and it's always difficult to compare these double lot homes because they have value, and often the sale price is listed, for just one of the lots. And so I'm just trying to look at what her logic was, for land and for house. I guess for house, I'm assuming if there's a garage, she's not considering her garage, but for the house, she's looking at the house value of other homes, right, that are similar square footage to hers and using an average, which isn't we kind of don't want. What I really like to see is the total value of her property and then other similar homes, that sold with the same, the price comparable to that. I'm not really saying.
So you're saying the price of her home isn't accurate? I'm not really sure what you're saying.
It's the comparable sales, right? Like at 2887, is she just taking the square footage? I don't know. I just need to look. I think I need to look at the numbers a little more. Her Creekside property is valued at $42,000, right? So it's not.
I have to double check that.
Yeah, I don't know what she's asking, but it would almost be like, okay, well, let's take the total value of what she wants.
The town valued her other property, which is, 42,000, right?
Right. She's got 0.78 acres.
But we're just talking about her house right now. We're not talking about the property which is across the street.
So that was
I understand what you're saying, Kathleen, but I don't want to conflate the two, I guess.
Yeah, and this was one of the discussions. I don't know if we had it on Thursday night. Ronique started is how do we handle these properties when they have, two separate deeds but they sell together? How do we figure out the sale price? How do we compare apples to apples to make sure that we're looking at them, as a total sale?
So what's the question that was asked of Ross? Did that get answered? Is this land calculation based upon both parcels or one parcel?
I mean, the thing is, Kathleen, I'd have to ask her so we can table this if we want that information, because I can't guess.
Yeah.
I don't think any of us can.
Yeah, and to be fair to the applicants, we asked them to file two separate appeals, but the reality is the marketability of the properties is both of them together. And often when they sell, there's only one sale price recorded. So it's really hard for us to say, okay, someone paid 2.6 million. Well, 40 of that was for their Creekside lot, and the rest of it was for their other. So if we can't break the sale out, how do we compare it? And that's and we have 12 or 13 of these, so this isn't the only one that's going to be like this. It's hard to, I don't know what the answer is.
I'm comfortable. If we want to need more information before we can render a decision here, I am more than happy to table it because I think that's probably in the best interest of Ms. Purcell and her taxes. So I'm happy to do that.
But this is Harold. The other thing I notice is that in doing these calculations based upon averages, when you have very low and very high numbers, the average doesn't seem to be a good way, a fair way of coming up with a number. If we were to compare more apples to apples, such as the other houses that are over 4,000 square feet that are also on close to a half an acre of land, then maybe that's a better comparison than mixing in houses that are half as many square feet in living space and smaller lots. I mean, that way of coming up with the number as an average when you've got low and high mixed together doesn't seem to me to be a rational way of doing it.
Again, I'll ask Mr. Murray if he has any insights to share on this.
I'm sorry, I didn't quite.
If Ross has any insights to share, I would love to hear more.
Do you want
Yeah,
me to ask Ross to come up with the
I'm not
rationale?
really sure where to go with an answer. I'm not sure really what the question is. It seems like the question is on the comps more so than on the subject.
Yeah.
And that would, of course, take a little bit of time to research.
Okay.
Yeah, or this is Kathleen, or the other question is, for you and Mr. Fazio, when you looked at these homes, did you look at the two pieces completely separate, or did you try to, put them as one value, and then, when you're testing your model and all of that, and there's sales down there on both sides, do you add them together when you test the model? Or, it's really hard because there's two deeds. If there was one deed, we wouldn't even be talking about this stuff. We would just be looking at how she did her, deciding whether we want to use square footage or not as a good, case.
This is Harold. Are there two deeds here or are there two cards?
There's two,
Well,
I think there's two
for
cards.
sure.
There are two cards here.
I think there's one deed, right? Or they sell together, I should say. Probably, if you look on the cards, there a sale price somewhere. 823.
It looks like there's two. This is Ross. Looking at the book and pages that were recorded, there's two different book and pages, 56, 56, 83, and I want to say 72. So they look like they were recorded very, very close to each other, maybe back to back, but there does appear to be two deeds.
This is Paulette. So if we have two deeds, then we have two pieces of property. No?
That's what I would assume.
Yeah.
A realtor, huh? You're the expert.
Property, yeah.
That means she can sell the Creekside lot without selling the house. Is that right?
I think that's some of the argument that they have. They're two different deeds, but they're not allowed to sell those Creekside lots. And they're somehow attached to the other side. So to me, if it's two deeds, it's two pieces of property, but
All right, perhaps we should set this one aside as well.
Yeah, because there's $0 on the sale of the Creekside lot, right? It looks like she bought it in April of 18, and the sale price is 0. So when you look at when she bought it, the other one on, the sale price probably includes both of the lots. And that's when it just gets tricky when we're looking at sales. But again, she also used square footage to do her, analysis, which I'm not, I don't particularly
Well,
like.
honestly, there's no template to do an appeal to give supporting data. We don't, so she did.
This is how, that's why I'm curious to understand if the square footage on this particular vision card includes all of the properties that are associated with this owner. Even though they might have two deeds, but if it's sold together, then the square footage of the land should be combined. And I don't see if it is or not. I don't know. I don't have sufficient information.
This is Ross. No, the land is on two cards.
Okay.
So can you tell us I only see one card in the file. Is that correct? Anyone see it, two cards? Can you tell us what the land is on both cards?
Yeah, the second card is 0.78 acres on the Creekside lot. It's got a 0.05 condition factor, but it's almost 3/4 of an acre. Valued at $2,000. It's a WP4, which means it's not Creekside's water proximity. It's at the beginning of Fairfield Beach Road. They probably don't have a dock, right? Can't have a dock.
And this is Harold.
Yeah.
Is that in addition to the 0.559 acres on the home site?
Yeah, it's separate. That's right. But But
So-
they're also, they have separate cards. They're valued very the land's valued differently, right? The beachfront looks like she's got I'm looking at the card for the beach. She has a 1.2 site, a condition factor on it. It's probably because she's got more than a half an acre of land. So that's why her land is valued, that 1.2 is bringing her land up. I'm not saying that that's not appropriate. I'm just saying because she does have a really big, much bigger lot down there, but that's the 1.9 on the land and then the other on the house. So I'm looking at her thinking, I'm just trying to, let's see. So table 1 is really how other properties are valued. Is that what that is? It's not sales data. It's just taking a look at other properties on the beach and looking how the town has valued the other properties.
Yes,
Really,
they compare the closest comps to their property at 869.
right, but they're
And it's
not
only
sales
including
comps.
the
They're just-
waterfront.
Right, they're just other homes at the beach and
No,
how.
they stated that that they're the closest comps.
Right, but comps in terms of houses that are the same, not comparable sales. Where table 2 is sales. But the only thing she did with the sales was to do the square feet on the recent sales.
Right,
Right,
she has 2 different scenarios, right?
right. So scenario 1, right, because all those houses could be too high or they could be too low because that's the value the town put on them. That's not sales comps. So really her table 2 is her sales data table. That's what I'm looking at. And I'm just trying to see, did she make her case with the sales data by doing a price per square foot of I think of the house, right? I'm just trying to look at the math, average sales price per square foot. So she look at she's doing it. Yeah. So like I said, table 1 is, it has a lot of data there, but it doesn't help me with sales on the beach. Table 2 is really where the sales are, but the way that she did it, she just looked at the house.
Yeah, but Kathleen, you know that there's no no one has, when people appeal these things, they don't have a template of how to do it. She did it in the best way that she thought she was doing it.
Yeah.
So,
I'm not, yeah.
I think we need to be a little less harsh here.
She lists a couple of properties on table 2.
Yeah.
Property at 831, which is certainly within her range of square footage of her home.
And 1641, right?
1641, which is also in her range of square footage, but those are not included in the land estimates above. If we look, well, 831 is, I'm sorry.
Yes, so those are 2 good sales, right? That at least have the same size house as her. The question is, are those the most similar ones? Do they also have the same amount of land to know where is she at now?
Well, if you add those 2 pieces, she has over an acre and a third of land.
No, what's their value? The town has her at 4,024,000.
At 0.0 million.
4.0.
She's asking for basically a 10% reduction.
Right. So I guess my question is 831 a good comp? Is that a very close comp for her land and house? And if so, then I think she's pretty correct at the 4 million. If the 831 is a much bigger house and much better than hers, more land, more house, then I would start to look at the other comps a little bit closer. But I need to look at, I guess 831 is the one.
831 has an acre less land.
What do you mean
It
acre?
has 0.45
It's
versus the subject house, which is 1.349.
If you're adding the creek, but if you take the
No, her acre acreage is 0.56.
I don't know when it's sold since August. So that is a recent sale. So 831 would be, looking quickly at that list, just based on square footage, 831 and 1641 are close to her home square footage. I don't know about age and all that other. And then, I have to look at the land. So.
Well, this is Harold, if we use those as comps and we don't take the average when we have market value homes of less per square foot price, and the sales are not in the same category in terms of square footage of living space, then she is on target, more or less.
That's what I'm looking
Yeah,
at.
and I would also add, I don't think the creek, whether we want to add it or not, it's not really consequential here. It's not worth anything. It's valued at maybe $40,000.
And it's valued accordingly, yes.
Right,
Well, she, I think, differs on that.
right. So
I mean, even if we took off the $40,000, that would still not get her to where she wants to be.
right. So 2013. So I'm just looking at that 831. Right. It's built in 2013. It's 4,400 square feet. It's on 0.44 acres. So it does, it has a 1.0 condition factor on. It doesn't have the 1.2. It didn't bump the land up, so that land is worth 1.5. But that sold for. Oh, see that. Oh, it sold for $4,150,000. Town has it at 3.8 million, but it sold for $4,150,000 on December 1st. What's her square footage?
Which number?
I was looking at the size of her house, 4665. Oh, I have it up there. And then there's that second comp with the similar square footage as well, right? And her house was built in 2019, so it's newer than the 2013 one.
I think it was 2018, wasn't it?
The card says 19, but maybe
Okay.
depreciation of 5. So, and she's got, she does have a bigger piece of land than the one that sold for 4.1. That was a December sale, but it probably contracted right around in October. So that might be a little bit high. And then the other one that was much lower was what, 1641? What does that one look like? My comp sheet out.
So other than the fact that she did an average of dissimilar sized properties, is there any other evidence or justification for going down to the value that she requested? Paulette?
Yeah, I don't see a problem with what she did. And she also accounted for an extra 20%. She's gotten her right up here because her house is new construction. She applied a 20% premium to bring their expected price per square foot to market value. So I don't really see too much of a problem with what I'm seeing here, the way I interpret it.
This is Harold. The problem I have is if I take out those low numbers of houses that are much smaller pieces of land, that does not support her estimate of her value.
No, this is Kathleen. So much of her value is in her land, right? She has a really big piece of property on the water. So that's why the 831 is a really good, and she did square footage averages. So even if we just look at her sales, the 831 is probably the best sale on the list. I just looked at that 1641, but that's only on 0.2 acres. It was built in 2000. So it's older. It doesn't look like it's FEMA compliant. So that's a much lower sale than hers. So I would say that one that sold for 4.1, $4,150,000 it's a smaller piece of land and it's an older house and it sold for 4.1 in December. So she's probably about right at right around 4 million.
So I don't know because I don't have the map. Her neighborhood code is 66, right?
Yeah.
Yes.
Condition is 1.20, and that's the land.
This Kathleen, Ross can speak to that, but I saw it on another property, and that because her lot is more than a half an acre, there's a couple of them down there at the beach that are very big. So the land tends to get bumped up for the really big lots because at the beach, right, a lot of land is very valuable. So it takes that site indexes for the size. So
Why-
It's a relatively small size of land. It's only 0.56.
Yeah, it's not huge, but But,
But it's at the beach. That's a half acre at, on the water. So that's why. But again, I'm looking at the sales price. It's just that 4,151,000 that's older. It's a 2013, and it's on smaller lot, and it's sold, in the low fours. So I just don't, without some other good reason to say, look, that comp has this and I don't, or I have these other issues that, you're not talking about. But her argument was square footage on the house only. So we're sort of researching her sales a little bit more, and I'm just not finding anything, to support. And maybe she has a case and she wants to, come back next year with more information as to why that 4.15 isn't a good, comp for her. All in all.
so while we're on this property, this way I don't have to go through this every time we do one of these. While we're on this property, so this neighborhood adjustment, 2.250, what's that?
That's the entire, all of 66. That's the land value for neighborhood 66. So every property in neighborhood code 66 has a 2.250. Every,
So that's-
right? So all the other neighborhoods we've been doing had 0.7 or 1.5.
Harold, yeah, this is Harold. Even 831 and all of the other houses that are listed have a neighborhood code, which is 66, with an adjustment of 2.25 for big waterfront properties.
Yeah, and they're
all-
FB8s. They're waterfront, right? I think they're all, I'd have to look at them all, but they're also all FB8, which is another adjustment to the land. So they're all similar. Her land
So
is
they're-
just a little higher because she's got that 1.2 on the site index for having an exceptional, a very big lot,
so
But-
Yeah, but I would also add 831, it has a double frontage, 90 feet, and the subject property has like a 60-foot frontage, right?
Say that again, 831 has a,
It's had a double frontage with 90 feet, and then the subject property has like 60 feet frontage.
Right.
That's a bit of a difference.
where did you see it on the double frontage on the 831?
It is.
Is it in the notes?
It's on the card. Or excuse me, it's on a not on a card. It is on a map.
It's on the map. You can see it on the MLS. You can see how many feet across there are.
I would like to ask Ross this question. The subject house has a condition of 1.2, which I heard Kathleen say is because of the excess acreage. There is 24,362 square feet. Should there be, and this does not include, as I understand it, this does not include the portion of the land across the way on the creek side. If that's the case, and if this acreage of 0.559 has excess acreage, which bumped it up to the 1.2, is it doable to consider excess acreage on this portion if the acreage that's there is more than this house needs?
I mean, this is Kathleen, but you gotta, before you start doing that, you have to look at the total value of the property first, right? If there's a problem, then you can see why there might be a problem. I'm just looking for why there's a problem before we try to, again, because of the 831 sale, unless 831, has a huge creek lot in that 4,150,000 price, right? We don't know. You'd have to look to see what sells with 831 Fairfield Beach Road. Is there a creek lot that goes with that has, a lot of things on it? And so in that $4.1 million sale price, there's, a 3-bedroom apartment on the creek side. I don't know. And that's why I get a little hesitant when we start to, even though this is a good sale, we still have to make sure we know what's in the sale price, because they sell often with the creek price in it. And we don't know if 831 comes with the creek.
So again, just to make sure I understand and confirm, this land acreage includes the creekside portion as well, or it does not?
Does not.
Right?
Does not. Okay. All right. That's what I was trying to, I was considering looking at. If it doesn't
Right,
include
and
the
when you look
side,
at this,
then-
Kathleen, when yeah, 831 does not have any creek landline in it, but that doesn't mean that there isn't a separate parcel across the way that sells with 831 that's in that $4.1 million price tag, right? We don't know that.
well,
You have to
I think
figure
I've,
it out.
Would you
I've
like me to look that up?
I've
Yeah,
heard,
Ross,
That
would
would be
you,
great. Thank you.
yeah, that's helpful because that's a, like I said, that looks, it's older than her house. It's a 2013 home. Hers is what, 2019? But it's
And
very
based on the
similar.
map, 831 is showing at it's like 18,000 plus square foot lot, and 869 is less than 12,000 square foot lot.
Would you like to see the aerial?
Yeah,
Yes,
because
please.
because it's a half an acre. That's what's confusing to me, right? More than it's a bigger lot, according to the field card.
Okay, so 831 has no other creekside lot. I see nothing else owned by that individual,
Okay.
just the one lot.
Okay.
And
so
the one that's
why we
highlighted is 831. And this is the subject 2 doors down. The creekside lot that the subject owns is this one here that you can see a little bit of cleared area for parking, that strip.
Okay.
So that lot looks, her lot looks, the subject property's lot on your map anyway, looks bigger than the sale, the $4.1 million sale 2 doors down. Yes.
all right, I think we've heard sufficient arguments on both sides. I'm ready to call a vote. All those in favor of voting to accept and grant the appeal as requested, raise your hand. I have 2 in favor. All those opposed, please raise your hand. I have 3 opposed. The motion does not carry. The appeal is denied. Is 2, 3, no abstentions. I believe it's Alexis and Paulette voted for the appeal. Yes, Paulette.
Mr. Chairman, if we're going to follow Robert's rules of decorum, when I'm asking a question about the property, it would be nice if people didn't talk over me so the question never gets answered. So the next time, can I please have the answer to my question before we vote for something, if that's okay?
Sure. The problem is, Paulette, that you're the only one that I don't see a full vision of, and sometimes I cannot see even your fingertips when you raise them. So please be aware of that is a limitation that I have. And also, we started off at one point saying, not only raising your hand, but calling out your name, each person's name. This is Harold, this is Paulette, this is Kathleen, this is Alexis, so on and so forth. And I think we should go back to that because that way we won't be stepping on each other's words and we will be able to recognize you when you give your name. That would be my recommendation.
I will certainly be wary of that. I'll do that in the future. However, I was in the middle of the questions. I wasn't asking to be recognized. I was already recognized and I just got mowed over. So I'm not, if that's the way it's going to be, I can do it too, but I'm trying to follow the rules. So if we could just follow that, I would greatly appreciate it. Today.
Okay, I don't think that threatening the chair is a good thing to do by saying if that's the way it's going to be, that's what I'm going to do too, because I'm trying to get everybody on the same page. So please, without the additional comments, we will try to work this out. If you wish to make comment now, I'd be happy to hear it, but I'd like also to be able to move ahead.
I didn't mean to threaten you, Harold. That wasn't my intention. I'm sorry that that's the way it seemed. However, what we didn't address was people interrupting while I'm asking a question. So that's okay. I got it now.
All right, let's give give your name and I will recognize you, or raise your hand high enough so I can see it, and I will not move to a vote until all questions get answered.
Okay. Well, I'm good.
Thank you.
You're welcome.
Alexis, you have another? I think that we just lost Alexis's connection.
Is there?
Okay, I saw a little triangle there. Alexis, do you want to take another? We have a lot to go through.
Can you hear me?
Harold, this is Ross. I think you lost Alexis.
I hear her, but I don't see the image.
I just my video on
Okay,
is hear me.
yes.
Okay, very good.
Just-
Okay, thank you. Sorry, I will continue. So we are with we're still with Mrs. Purcell. This is appeal number 387, 860 Fairfield Beach Road. This is the marsh side of the of her property. So I would like to make a motion to bring down the town's value of $42,000 to the appellant's opinion of fair market value of $30,400. And thank you for the good discussion earlier on her other property. Appreciate it. And she really made a pretty simple, comment. The market value, has increased. The land can't be developed. She also noted to me in her testimony.
Excuse me,
that-
we need a motion.
Oh, gosh, sorry.
We need a second.
Sorry.
Is there a second?
This is Paulette.
I'll second it, Harold.
She also, I don't know if this is material to the discussion, but she did note this, just look at my notes, that she believes that some of the property is actually shrinking a little bit based on, some of the, I guess, cementing or paving the town does on a fairly, whatever basis that is. And she thinks she's, losing some footage of that, but again, I don't really have any concrete, no pun intended, evidence of that, but she did note that. And again, she just doesn't feel, she can't do much with the land at all. And you can see a picture of it in the card. So, pretty cut and dry here, I think.
Yes, this is Harold. It appears that, again, this increase was due to the fact that much of the land in the area increased as a result of the revaluation and price adjustments that were made based upon sales in the area during the revaluation period. So unless there's some justification, did you say that some of her land was lost due to?
That's what she's saying, just due to, paving that the town does. It's obviously not intentional, but she feels like some of the land is getting a little, it's I guess, decreasing slightly, whenever they do paving.
All right.
I have a question.
Yes.
This is Paulette. I'm trying
Yes.
to put my hand up. Sorry. I have a question. So I looked at the picture of the land, as we all did. Now, she says she can't do much with it, which I believe her. But I'm just wondering, look at it, it's all overgrown. Is that land restricted where she's not allowed to clear it? Because that would make it even less valuable if that were the case. Do we know? Mention that? Does anybody know that?
This is Harold. I'll ask Ross that question. Is there anything in the card that indicates that it's prevented from being cleared or mowed or anything of that sort?
Is it wetlands or?
Well, this is Ross. There's nothing in the card. I can tell you that in this case, the landline is split so that we do have 0.67 acres as excess and 5,000 as the primary. If you like, I'll pull it up on the GIS here and we can take a look.
Okay.
Give me a sec to pull that up.
So as I see this 0.67 has a site index of 0 and a 0.5. So that creates a factor of, okay, $8,300.
So this is Ross. It does appear that most of that is wet or in a buffer.
So
Yeah.
it's not, you can't build
Hers
it, build on it?
This
Yeah.
is her piece right here. I don't know if you can see that.
Yes?
It's
Yeah.
not where the
Yeah,
dot is
yeah.
on the, it's got that little area right there. You can see that's her area that's cleared for parking.
Okay.
So this is Kathleen. So it does provide her with some parking. And didn't the town purchase one of those, Ross, does the town own one of those long ones there? Or am I thinking of someplace else? I thought the town bought one of those ones right there so you could have creek access, like in the last, we
I
probably
believe you're
paid,
correct. Let me take a look.
market value for it.
But if they bought a lot that was creekside and it isn't full of wetlands, then that value would be very different, because not only can they not build on these, she can't even cut that grass. So the part that's clear that you see is all she has use of forever.
She park on it, right? I guess that's, it's, this is
Right, but that's
Kathleen,
all you,
parking.
you can't, but that 3/4 of an acre of property that she can't even clear to make more parking. That's what she's got to use. That's the end of it. Doesn't get any bigger than that
Mhm.
forever. That's the way it is. So that would devalue that land, to me, a significant amount. And, that was never noted. I guess nobody questioned it before, but if it's really wetlands and Ross says it is, then there has to be an adjustment made.
Yeah, it's,
Mr.
this is Kathleen, the
This is
town bought
Ross.
908. The town one is 908.
It's not, it looks like
Yeah,
a much
it's
bigger property too.
It's bigger property.
It's the, never mind. Kathleen, this is Ross. That piece that the town owns was bought quite a while ago. And it's the one next door with no frontage.
2015, right? It was bought.
So then it doesn't have any bearing in what we're doing now.
But yeah, it's a much bigger
No,
property.
I show the town's had it since 82.
Oh, there we go.
908 Fairfield Beach Road.
Yep.
No, sorry, wrong one. Let me look at that.
Yeah, I remember that sale because I don't know if we did an appraisal. I don't remember how the town came up with that price for that. It's a bigger property, but it was owned 1/3 by the town and the other people wanted to sell it. So I think the town bought out the interest of the other parties. And there was an appraisal done at that point in time. So I'm saying that particular property, sold for it looks like 268. I don't know if that was for 1/3 of it and it's bigger, it's 2 acres,
Right.
but.
Mr. Chairman,
Yes.
It's this large piece.
it's Alexis.
Here.
I'm not really sure where we're going with this conversation, how it's germane to this property.
Well, I think that we were looking for comparable land values. That was my understanding. If that's not correct, then we don't have to pursue this further. But I do see that this land was purchased in 2018, and there were no appeals in previous years issued, and the appellant has come back this year because the land values in the beach area have increased, and that changed her value. And I understand that, and that is the case with many of the appellates who are situated in the beach area. So I think that it's like a cost of living thing. If you're living in the beach area and your appraisals are increased as a result of land sales and property sales in the area, then rising tide rises all boats, and sinking tides lowers them.
Yes, and if I may, Mr. Chairman, the property that Kathleen was referencing is a far different piece of property. It's much larger than the subject property.
Yes.
So they're not comparables at all, actually.
We don't have to go there because really we're not comparing properties, we're looking at the increase that was made by the town in the assessed appraised value, and we are comparing, looking at what it was previously, and we see that the appellant is seeking to go back to the previous appraised value, and a lot of appeals are centered around that. Paulette, I see your hand up.
Yes, thank you, Harold. I agree that that property has nothing to do with this one, but on this one, she might be looking to go to the previous value. But remember, the previous value does not have any adjustment for the wetlands that we now know are on the property. We have to adjust for that. And although property values went up on Fairfield Beach Road because that's what we've been told, and we can see the evidence at times, the properties that are not buildable do not rise in value at the same rate as the ones that are. So property values may have gone up, but they don't go up on those creekside lots like that because you can't do anything with them. And in her case, there is really what you saw cleared is it. There is no more. So she has a really good case for dropping that value down to what it was. It was overvalued at 30, whatever it was before, because we didn't know about the wetland.
Well, this is Harold. If we looked at a previous card, we might see that the Topo Marsh site wetlands is marked on that card as well. I don't know when this was added or if it was changed from a previous card. I believe it was there from at least 2018. Ross, is there any way to know that the topo information was just added?
This is Ross. Let me look at the prior card. Now I'm looking at the 2019 card, and it's actually doesn't appear to have any changes. The condition factor is the same. It says Topo Marsh. It's split between a primary 5,000 acres and the excess 0.67. So it's really doesn't look like anything was changed on this card other than the adjustments.
All right, so this is Harold. Given the fact, well, let me just say, given the fact that we know that the property values in the beach area have gone up, and there's nothing to indicate to me, at least, that there's any change in this particular parcel of property to regress to the previous value or change the value. I don't see any justification for considering a change in the value. Yes, Alexis.
I think what, Mr. Chairman, if I may, I think what you're saying is, yes, you're saying the properties in the beach area have gone up, but that's not for us to say. I mean, there are a number of people still appealing their properties in the beach area, so we can't really render that decision. And I disagree with the comment that you made about the cost of living. No one is living on this piece of property. It is a small, tiny lot that you can do nothing with.
I understand. I was using it as an example. I might not like the fact that my taxes my federal taxes might go up because changes in the federal government or what have you, but that's what we're dealing with. We are dealing with the tax, the valuation that the town has set upon the property. And we sit between the appellant and the town, and we have to look at all of the evidence to determine, is the amount that the town is seeking based upon the appraisal, or is the amount that the appellant is seeking based upon their what they're claiming or what they're saying is the justification for that. And we have to decide on which one is right. And if we don't see any compelling evidence from the appellant, then what do we do? Just give them what they ask for? I mean, that would be the same, everybody. I mean, if the town did not have any way to enforce the collection of taxes based upon valuations and say, okay, we're not going to enforce our tax rules. Who would pay taxes?
Right, and I don't think, and I won't belabor this point anymore. I just don't think that we could always say that. I think I'm hearing from you, and correct me if I'm wrong, that the town is always right. It's not always right, actually. And in the Peak area, there's a lot of.
This is Harold. I believe that it's right until it's proven wrong.
Okay.
Harold, excuse me.
Yes, Paulette.
I understand what you're saying, but I do need to ask Ross a question. What you're saying is that no change in the field card since before, so that she doesn't have a case. He's got marshland on here. Marshland is not wetlands. So I think there's a different distinction. So if that's true, then that card, we need a card adjustment to account for the wetlands. So if the marshland, because I've seen wetlands on the card, on other cards, I don't see it on this one. We now know that there's wetlands there. The fact that the appellant didn't know it, but we now know it, that's our duty then to be fair and honest.
This is Harold.
It has to be made.
Yes, I understand, Paulette, and I think that you are right in addressing the question to the assessor's office, because I cannot differentiate the definitions of wetlands and marshlands as it pertains to what is written on the card. Sometimes we call it wetlands, sometimes we call it marshlands. I don't know how the town how it differentiates between those two descriptions.
So if he could tell us that, it would be helpful.
So let him have an opportunity to answer.
Sure. Yeah.
This is Ross. I honestly don't think there is for us that we use a definitional difference between the two. I think this is in a marsh and it's marshland and it's wet, and that's how it was. The reductions to this compared to others was noted.
This is how.
I think you're looking for more definition than we actually use.
Okay, then.
I suppose the real definition is, are they both, do they both have the same condition factor? If they have different condition factors, then there's a difference in the definition. If they have the same condition factor across the board, then they meet the same thing. Yes, Kathy.
Is that to me, Harold? This is Ross.
No, go ahead, Rob.
Yeah. We don't have a table of adjustments. So we don't have a table that says, marsh is minus 0.5, wetland is minus 0.1. Each lot is looked at individually to see what it is. So that's how I would determine it.
Okay.
So it's not, it's not just a standardized number. We look at each lot and apply what we believe is appropriate.
Then my next question, then Ross, just to finish this up, to clarify, is if it's considered marsh, okay, which is what you've labeled it, if that woman wants to go in there and cut that whole thing down, can she?
I don't know. I'm assuming marsh is the same as wetland, and then
No,
it would be no.
If I may, wetlands are, based on my experience, wetlands are tied to, they're linked to land and water. Marshes are different, right?
Yeah, so I guess.
There are tidal marshes or freshwater marshes and so forth.
This is Harold. Aren't these questions that should be addressed to somebody who's responsible for determining that, i.e. conservation or whatever commission or department in the town is responsible for determining what wetlands and marshlands are, and it's not necessarily the purview of the assessor's office to do that?
That's correct, Harold. I was just going to suggest that we contact conservation and find out if it really is wetland, because if it is, it's much more restricted, and that would make that property much less valuable. So I think we have an obligation to find that out.
This is Harold. It does address the question of whether she can go in there and cut down the reeds.
Yes.
That's not a question that the assessor's office or the board can really answer. Yes,
right. So,
Sorry, Paula, I was just gonna say, maybe we table this one before, so we can get a definitive answer from the Conservation Department.
You know, I don't see a reason. I think that there's coding on here that takes into consideration the wetlands, whether it can be cut or not. I don't think that's the issue. I mean, that's not, she didn't ask about cutting the reeds. She didn't ask about cutting the reeds, did she?
No, but
I
if I
did.
may, Mr.
Yes.
I was
Alexis,
just gonna say, she told me in the appeal that this house is, excuse me, this property is not buildable. So, you know, we can make assumptions that it's because of their wetlands, there are you know, whatever, there are issues with the land and that it's just not buildable for environmental reasons. Okay, so maybe I can just check. I
well,
mean, I know that we want to get through these appeals, but I can ask.
yes, but that's why I think that the coding is appropriate for the fact that it's non-buildable. It's very low coding of what would be buildable land. Yes, Kathleen.
Okay, so there's 3 lots that are very similar there on the north side. Now that we may need to postpone this, but Ross, she's 860, right? 872 and 890 look very similar, but they do not have the WP4 code on them, and they have a lower land value than hers does. She has a WP4. So my question is, did it get missed on 872 and 890? Or was there a reason why it wasn't put on those 2 lots and therefore she shouldn't have it either? So, and I don't know if you can answer that now or not, but I did notice, you know, because if you look at 872, it's worth a lot less money than it's valued a lot less than the town, than the subject property, and it's bigger. So the question is, why is that? Is it because she can get cars, you know, she can park cars on this lot and now when they can't, and therefore the WP4 didn't get put on the 872 and the 890, and that's why those 2 lots are lower? I just, you know, most of the lots on that creek side have a WP4 on them because they're water proximity lots. And we know, parking's at a premium down there. So what I pay, if I had a house down there, I probably would pay 40 grand to park a couple cars if I had a small house. But
This is Harold. I think
coding.
I think the answer to your question is, it would have to take into consideration whether those properties are split the way this one is in terms of apportioning the different condition factors to different parts, i.e. the 5,000 square feet.
They're exactly the same. They look the same on the card. The difference is that the 5,000 square foot line has a WP4 on it on her property and not on the other 2. That's what I'm saying. They look, you know, they're marshy lots. They're, you know, we know where they are. They're right as soon as you start down Fairfield Beach on the right-hand side. You probably can park a couple cars on them. You know, a lot of those small creekside lots, you can't put a house on them unless there was a shack there before and you can, you know, build something else again. I'm just curious as to know why those other 2 don't have the WP4 and she does. Is it it's her better lot, or should she be where they are?
That's a very good question, and I think that it deserves an answer. So, Alexis, you had your hand up, but
Yeah, I just wanted to make one other quick note, because I actually, Kathleen, in that same vein, I actually asked her if she could park cars there. You know, parking is probably a premium down there. I don't live down there. I can't really attest to that. Maybe you do. I don't. But and she told me, no, I don't do anything with it. It just sits there. I don't park anything. I don't pay. I don't have, you know, people paying me to park my car there, whatever. So I don't know if that's helpful, but I did ask about that because that wasn't
whether she can or not, right? And she chooses not to.
I don't know if she can. I can't make that assumption, Kathleen.
Yeah, she didn't say that. The other. It's not paved, right? We see that. It doesn't look like it's paved.
Kathleen, 1 minute. I think that you raised a good question in terms of consistency of the information that's on the cards. So my suggestion or recommendation to Alexis is that we withdraw this motion. We investigate if there should be a change in the appellant's information based upon the other 2 pieces of property that Kathleen mentioned, and see if that creates a beneficial situation for the appellant. You wish to withdraw?
How about no action?
Or take no action, I should say?
Yeah, I mean, it is parked right. I mean, I think this lot is right near condos. I don't know if you can do anything with it. much less park cars. I'm happy to withdraw it if that appeases the board, and we can certainly fact find further.
That's what I would recommend. I think that for the sake of consistency and to see if the appellant is incorrectly, has their property incorrectly valued based upon other comparable pieces of property, that it would be beneficial to withdraw, take no action currently, and we'll investigate this along with the two other properties. And doing that for the potential benefit of the appellant.
I agree.
Okay.
Okay.
I will, if I may, I will withdraw the motion then. After another spirited discussion, which I appreciate from this board, so thank you for all that.
Take no action.
Okay,
Take no action.
okay.
So Alexa, you're going to conservation, or you're going to check with conservation on that?
Yeah, I'll call Sarah at the Conservation Department.
Okay.
And on the other hand, side, I think it will be beneficial if the assessor, if I can ask the assessor to compare this parcel with the other two parcels that Kathleen mentioned, to see if there's a coding error that should be taken into consideration.
One more,
I'll do that.
would note, it does look like the lot next to it is a lot bigger and valued at 10,000 less.
Right,
Just
this doesn't have a
thought
W,
as we can.
yeah, it's that WP4 is not on that property. That's what, I believe that's why it's happening. It's not on the other two, the McAleer property. And she owns a house across at the beach, so it would be very similar. McAleer has a house, right? Someone's got that appeal on the beach side. So, that one or that other one. So it's good.
I'm not familiar with that property, but okay.
Yeah, they should be, I would think they would be treated the same unless there's something very different between the two. So that's good.
Well, this is Harold. Let me ask you this. You have another property, a small parcel of land on appeal number 178. Since we're, and also one at appeal number 165.
Oh, that one, yes. Oh, that one.
You want to look at those in the same
Yeah, I
vein?
don't, so I was going to take the follow-up. Oh, I do have the information here. Yeah, give me a 2-minute break here, and maybe we can defer to another board member here. If I can just review this one again, if you don't mind, but happy to go to this one tonight too.
Okay. Well, we do have Peter and Kathleen available to hear some of the appeals that they have on this list.
Yep, we were going to do 10 tonight, right? We've done 1. All right, Peter, let's go.
All right, Peter, do you
So I was trying to get the easy ones out of the way so we make some progress, these ones that aren't so complicated, but that's okay.
Okay, so this is, let me just get it up here. Appeal number 2.
okay?
All right, so this is appeal number 2. The property address is 56 Fairfield Beach Road. Aaron and Brendan Biggins are the owners, and they were the appellants. They're requesting, or I'm sorry, the town has valued their property at $1,283,700, and they are requesting a value of $1,172,000. I make a motion to grant the requested value at $1,172,000. Do I have a second? All right, thank you, Kathleen. All right, so all right, so they provided the appellants came in. This is a home that they bought for $1,100,000 back in December of 17. Looked like it was an estate sale. I believe it was an estate sale. All right. And let's see, they did have an appraisal done that on 8/13/20 that came in at $1,172,000. All right. And then they also had a previous appraisal back in 17 that came in at $1,150,000. Anyway, just some things to note. This was, it looks like it was, even though the house was originally built in 1950, it looks like there was some fire damage, and so rebuilt in 2005. It does have a depreciation, of 30% on it. It was, the kitchen appears to be remodeled, and in the appraisal, it does say that it was less than a year ago. That's on page 8 of the appraisal. And if you look at the picture, from they have 2 appraisals in here, so it's a pretty lengthy file. If you look at page 66, is a picture of the original kitchen, and then look at page 8 of the file, and you can see the newer kitchen. But they did note that it was, in fact, less than a year ago that kitchen was updated. There is a size adjustment on this property of 1.3. All right. It is about 3,548 square feet. It's on 0.224 acres. All right. And let's see. Okay. So, they said that this sat on the market for 6 months. I don't know if that is, actually it says in the appraisal again that it was on the market for 41 days. This wasn't a estate sale, so I'm not sure that they're talking about the layout of the house is functional obsolescence. There is no garage, but there is a carport. Let's see. Again, they live across from the Fairfield Beach Club parking lot, and they claim that the view and the parking lot is noisy in the summer. But again, in the the appraisal, they do comment on actually that specifically, and say that's not really an adverse condition. It was raised in 04, but it's not FEMA compliant.
Peter, this is
Yeah.
Harold. You're saying it's not FEMA compliant?
Right. It was raised in 04, but it's not FEMA
Not
compliant.
enough. Okay.
Yeah. So, let's see here.
Well, we have a recent.
Okay, go on. Yeah, right. So I'm going to go through that right now. So they do say that the subject did not flood during Sandy. Right. That was in the appraisal on page 56. Right. Did not flood during Sandy. All right. So they did provide this. As I said, they did provide a couple comps. One was 634 Beach Road. All right, which is 0.17 miles away. This was adjusted. This was a sale in 420 for $1,109,000, and it was adjusted here to $1,106,000. It was a house built in 2005. So similar kind of a situation as them there, or at that site there. Let's see. Right. Similar square footage, a little less acreage. All right. 3345 Roland. This is 0.45 miles away. And adjusted it's sold 120 for $1,210,000 and adjusted to $1,172,000. And again, the second story was added in 2005. All right. Smaller square footage, a little bit larger acreage. there. Let's see, 97 Carolyn Drive. That's closer. That's, really kind of like right behind this. It's just 0.05 miles away. And that was sold 120 for 1,320,000 and adjusted price of 1,196,600. Definitely significant updates between 2004 and 2016, according to the field card. Similar square footage, slightly smaller, slightly larger on the acreage. And 293 East Lawn, they provided 293 East Lawn. I did not see that this was a sale. I guess, maybe it was for sale, but didn't sold. So they had an adjusted price on this, or am I wrong? I don't have a sale on there, but that's also 0.85 miles away. An adjusted price on there for 1,180,000. Truthfully, I didn't feel like the comps that they were using were really, I mean, the Carolyn Drive is right there in the same area, very close, but certainly not on the, not with a beach view, not with a water view. I mean, this does have a limited water view. It's not, full water view, but it does have a water view. So, and even, I'll just say, my first thought was, all right, you're on that, Fairfield Beach Road, but even the appraisal said that that's not really a limiting condition, adverse condition. So.
No. Yeah.
Does anyone have any thoughts about the appraisal? Yes, Kathleen.
This is Kathleen. I'm just looking at the appraisal. I mean, the second one is a 2017 appraisal, so I definitely wouldn't look at that one. But this one, again, the sales, the Roland Road one is a December 19, and both of the other ones, even the Carlin, and the Beach Road, those are April of 2020. And I just think, and the Carlin was sold for 1,320,000. He adjusted it to 1,196. But I just think by the time you get to October, he's pretty much right. I would, assuming Carlin's the best at 1,196, I don't think, 5 months later at 1,283 that's incorrect. I think the 128 is a pretty good number. I don't see him coming down lower than the Carlin, that was an April sale. I think it's pretty close.
Harold, I don't see that much conflict with the recent appraisal and the value that it has put on it, because I think that the houses that are in the area, and they differ somewhat in age, in square footage, in acreage, but they're in the ballpark, and that number is honestly quite close to what the town has. So I don't know that this appraisal is that far off.
No, but it's older. That's what I'm saying. The sales are old. They're not, you don't see the September, October sales in this appraisal. And maybe it's because it was for a bank refinance and he did it. When did he do it? It was as of 8/13. I just think they're a little old. And I think by the time we know the beach went up so much. So April, to time adjust right around there, I think he probably would have ended up at 1.2. So I think he's okay. I wouldn't, just because the sales are older. I think it's good. And I think Carlin, I would definitely not use East Lawn. And the Roland Road one is way up, that's not close to the water. It's a half a mile away. So I would really look at the Carlin one, and I think that, that closed in April. So I think they adjusted that to 1.2. So I think he's probably right at 128. I think that's right about right. That's me.
Yes, Paulette. Are you muted? You're muted, Paulette.
Thank you. I would agree with the comps had they been just handed to us by the appellate and no adjustments made. There's adjustments made. There's nothing wrong with the comps. We can't have every one of them be on October 1st of 2020. This is a reval of a period of time 19 to 20, things change. So if this is done in 2020 and not 2019, I don't even care if it's done in 2019. I don't see anything wrong with it. I think, like Harold said, I don't have an issue with the comps. I think that it's close to what the appellant is asking. That's the number that the appraiser gave it, using his skills to make adjustments. Therefore, I have no issue with this appraisal. It was
So my,
8:30.
just,
That's the
sorry, go on.
way.
Peter, in looking at this appeal, are we comparing homes in the appraisals that have similar number of bedrooms and baths and square footage and so on? I mean, this house you said that had some damage. It was built originally in 1950, I see, and the repairs to it were, I see, building permits issued.
Yeah, it's
when?
got, it's got, it was rebuilt, but I mean, also I don't see the kitchen remodel on the field card, right? It does say that it has a, 30% depreciation. The Beach Road property is a newer one that only has a 93. The Roland at 85%, not 85, what I'm saying here, not 30. 30% and 7% and 15% and 14% for the Carolyn Road. And, roughly, I don't think the Roland Road, that one's pretty, it's pretty small. I mean, it's, almost, almost 900 square feet less. But everything else is generally in the ballpark there. I just, listen, I think there's value of a home that can, even despite the fact that it's across the street from the beach, does look out onto the water. And none of these other comps do that. And, I just don't really, agree with. I mean, I think some of the comps like the East Lawn and the Roland Road, I think they're very far away. I mean, I can make a Carolyn Drive argument, but they're not looking at the water from where they are. So, we're probably not looking at the water from where they are. So,
Yes, Paulette, I see your hand up.
Yep, Roland Road probably doesn't look at the water, right about that. But there are houses on some of those streets like Carlin that can, if they're newer construction, can see the water. They don't have a great view, just like this house doesn't have a great view. It has a limited view. And as far as the fire damage that we keep hearing about, that was to the house before this one was built. That fire occurred in a house that was a Cape-style home, originally on that property, that burned. And that's why they redid the house and ended up lifting it, even though it's not FEMA compliant now, it was at the time, lifting it and then rebuilding it. So that
Right.
fire damage with this particular house, it was a previous home on that site, which was then rebuilt, or actually not rebuilt, torn down and a new one was.
Right.
So,
right. 2005. That's all I, that's, what I thought I stated, that, was, it's just not, it's not a 1950 home. It's, it's more in line with the 2005 home.
Yeah, I saw that on the card and I just said that, but looking at the construction record, you can see that it was mostly rebuilt.
and as far as the
So-
kitchen goes, depending on what they did in the kitchen, they might not have had to pull a permit. If you're going to remove your cabinets and do your floors and put in an island with just an island and a countertop, if you haven't touched the plumbing or the electric, seriously, you don't need to pull that permit. The town would like you to, and I'm sure the assessor would like to see it, but that's not a must.
Mhm.
And we don't.
Okay,
Well, again, you could take a look at page 8 and page 66 and, obviously these pictures are not great. So, I just see it, it looks like a pretty significant difference. But like you said, maybe didn't have to have a permit pulled for it. I just, I think, yeah.
Well,
Anyway.
It looks like it has the original oil heat system.
We can vote.
It's depreciation code 5, the condition grade is a 7. I I don't know if we want to mess with any of those numbers. So why don't we vote?
I think we should vote.
All those in favor of granting this appeal to the requested value, please raise your hand. I have 2 in favor. Opposed? Please raise your hand. 3 opposed. The appeal is not granted. Motion is denied. The vote is 2-3-0. Paulette and Alexis are in favor.
Let me get the next one up here.
Sure.
Okay, this is appeal number 83. And this is 668 Fairfield Beach Road. The owner is 2103 Main Street, LLC. I don't know. I don't seem to have. I mean, I think Joseph Vole was the appellant, but I'm not absolutely certain. I don't have that in my note here. So,
Excuse me, I need the appeal number again.
83.
Thank you.
83.
Oh, there we go.
All right.
Whoa, sorry.
So this is a 1984 Colonial. It is in the WP4 there. It's let's see here. It does have a 0.95 for an easement. It is in the floodplain. There and has 75 or 25% depreciation. It's 2,436 square feet on 0.425 acres, and 5 bedrooms, 2 baths. It does have, some adjustment for, there's some adjustment on the condition, all right, of the land. So the appellant argued that that there, some different arguments here, right? That he's been trying to sell it for years. All right. Oh, first of all, actually, I have never made a motion, so let me make a motion here. The town has valued this property at $946,500, and Helen has requested an amount of $575,000. I make a motion to grant the appellant's requested value at $575,000. Do I have a second?
I'll second.
Alexis seconds.
All right, thank you. So the appellant says he's been trying to sell this for years. I mean, in the documentation that I saw here, it looked like the last time it was, on the market was 2012. All right, he's claiming that the highest and best use for this property would be to tear it down. He says that he only has, 0.1 usable land that it abuts to the beach grass, and then he provided, a bunch of comps. I can go through those comps. All right, so 678 Fairfield Beach Road. This is a duplex,
This is Harold. Am I missing? I only see four pages to this appeal.
Yeah, me
Yeah,
too. I don't have the comps.
Yeah, they were just in my notes. He just provided the comps verbally to me.
Okay, you're in your notes. Okay.
This is Ross.
Yeah.
The backup should have 9 pages
I see 4 here.
4.
on Appeal 83, right?
Yeah.
Correct.
Let me refresh it. It may have not been properly refreshed
Okay.
because I have 9 on mine. Give me 1 sec.
I put this on the list as a BP1, but I'm looking at the card. I think it's a WP4. Is that right?
Yeah, that's correct.
Okay, my bad. I put it on as a BP1.
And listen, I don't, since I only had the, I mean, he did verbally give me these, but unless he's presented something else or there was something else in the file that wasn't there, I mean, perhaps I should hold off on this one so I can go back and
Yep. This is Ross. He did have a couple of comps that he listed, and if you refresh, you should have 9 pages in the backup now.
All right. Well, let me see. Maybe I've done them.
This is Harold. No, I still see 4.
Yeah,
I got it. Hit
Okay.
F5, Harold. Try hitting F5. Will that refresh it for you?
No, I still see 4. Maybe it's because of the spreadsheet I'm working with. I don't know.
This is
When you
Kathleen.
go-
Harold, once you call it up, hit F5. Don't keep clicking on the link. You actually have to refresh it in your browser. Like you got to get the browser to go get the page again. So hit try F5 on the top if you have that on your keyboard.
Okay.
And that do it?
Sorry.
No?
Function
Maybe-
F5.
Yeah, there may be a refresh button too, but just the function 5 button is refresh, I think.
No, but go ahead.
All right. Well, so it appears that the only comp that it appears I do not have is 1522 Fairfield Beach Road. So everything else, he provided to me verbally. So I'll just try to go through them as quickly as possible. All right. So again, just to refresh everyone, this is about 2,436 square feet, 0.425 acres. I'm pretty sure this is it appears to be a rental, property. Okay. Which doesn't matter, right? So this is 678 Fairfield Beach Road. Was sold for $715,000. Looks like it was an estate sale in 8/21/20. It's a waterfront condo. Of 1,836 square feet, 3 bedrooms, 2.5 baths. 500 Fairfield Beach Road. Was sold 10/13/19 for $907,500. It's got a large pool that's just recently been installed on 10/1/20. Put $74,000 into that, according to the field card. And that has 1,440 square feet. So again, significantly smaller square footage, 0.231 acres. 1240 Fairfield Beach Road. That was sold on 11/12/20. It's also a waterfront condo, 1,100 square feet. Okay. 1094 Fairfield Beach Road. Right. That was sold 6/7/2019 for $875. Similar square footage and acreage, I guess. Well, a little bit less, right? That one has some adjustments to the for topography and the site and the proximity. All right, 1084 Fairfield Beach Road, that's 985,000. Sale price on 11/18/20. About quarter of an acre and 1,500 square feet. 2155 Fairfield Beach Road was sold 10/1/19 for $1,050,000. 3,200 square feet, much smaller lot though, much smaller lot. 939 Fairfield Beach Road was sold for $1,300,000 on 2/15/19. And smaller lot, similar square footage. It's also waterfront. That's also waterfront.
This is Peter.
Harold.
Harold.
You're Harold. You're not Peter. Sorry.
No, I wanted to say, this is Harold. Peter,
Yes.
I don't see how these comps are helping to support his case. What is he getting at?
I'm not really sure myself, Harold. I don't think they supported his case either.
Any further discussion or comment on this? I mean, they just don't work in terms of supporting his opinion. And if you look back in history and see what this house was purchased for in the past, it's in no way close to what his fair market opinion is currently. So I'm ready to vote unless anyone has some comments or questions. Yes, Paulette?
He's tried to sell the house for quite some time, not most recently though. And he couldn't even get 700 and change for it. The house itself is it's certainly not updated. It's certainly not attractive inside or outside. And I'm not clear on the use of his land. Does he say that he only has a small portion that he can use? Because the rest of it is marsh?
Well, right. He says that he says 0.10 usable land, but I mean, we could take a look at it. It looks like there were quite a few cars parked on it, if I recall seeing a picture. I don't know where I saw that.
Okay.
I mean, maybe we could look at that, because he says that it's in the floodplain. So maybe Ross, if you could bring that up for us.
This is Harold. Yeah, we can look at a map, but on the card, it says that a quarter acre is reduced 5% because of water proximity. However, the 0.210 acres is at 5% because it's recognized to be in a floodplain area. So I believe that's already adjusted for. And that's why that 0.2 acres is really valued at only $2,600?
Yeah, this is Kathleen, yes.
Yeah.
He wants to go to 575. Is that what you're saying, Peter?
Right.
His ask was 575.
Right.
So, and how do we know he can't sell it? Did he list the house?
It was listed for quite a few years in a row. He ended up renting it because he couldn't sell it. He's got a long history of trying to sell it, and then of renting, he couldn't unload it.
Okay.
Well, I mean, Paulette, you would obviously know this more than I would, but it looked to me like the last time he had it on the market was 2012. Is that correct?
Yeah, it was a long time ago. He hadn't tried in recent years. He had been renting it. That's correct.
Are we ready to vote, or do we want to ask the assessor to show us a map, or do we have any further comments?
Well, my pictures are online, right? Sorry. I just Googled the address and looked at it at a realtor. The pictures looked nice to me. So I'm ready to vote, but brand new Trex deck, kitchen and appliances, gas stove, quartz countertops. Am I looking at the right property?
Not the one I was looking
Oh, 678 Fairfield Beach Road. Do I have the wrong address?
668.
668. Never mind. 678 looks really good.
My only concern is that
Either way.
the Ross adjusted the land. So obviously, the assessor's office agrees that that land is not that usable as from a building perspective. So he has a point. He's not gonna, that value of the house is much too high based on the condition it's in now and the best use of the property, which he says is a takedown. He's probably right. But if he can't use the land, what can you build on? It's not gonna be a prime building lot. So I think he has a point that it's not, the town has assessed them too high. Should it be 575? I don't know, but certainly not 9 something.
Right. This is Harold. There is a quarter of an acre of good land that it's on, and there's already adjusted. And in this area, to the left and right of him, I think most of the properties back up to marshland, and there's adjustments being made, and there's significant reductions in that portion that's deemed to be marshland or wetland or whatever the determination is, but that's already taken in account. So I don't see how you can get down to 575 personally, and I don't think that the appeals that the comps that he sent in any way helps his appeal.
I'm not sure that they do. I'm just saying that maybe I misunderstood what they were saying about the land. So if I did, then, correct me. I thought they said that the land, most of the land is not usable. That they're like a quarter acre of it. It looks like a good portion of it has been drastically reduced in price because it's not usable. So I don't know that he has a good quarter acre unless I missed something.
Now, I think you did. If you look at the card, perhaps you'll see that there's 9,000 some square feet that is reduced by 5% because of proximity to wetland, and then there's 0.210, I think, as I recall, that is at 5% because it is wetland.
Oh, I see. Okay.
Okay, so I'm ready to call a vote. All those in favor of granting this appeal to 575, please raise your hand. All those opposed, please raise your hand. Abstentions? 1 abstention. The vote is 4 in favor, no against, and 1 abstention.
Kathleen, I think it's 0 in favor, 4 against. Am I right? I wasn't looking when you voted, but.
Yes, sorry, the hour is getting to me.
It's okay. Who
It's
abstained?
0,
0, 4, 1.
0 in favor, 4 against, and 1 abstention. The abstention came from Paulette.
Okay.
And based on the fact that I don't believe that the town's value is accurate. It's way too high. His may be too low. And because we don't really know what we can do with that land, I really don't feel comfortable letting the town have that value on that property.
Okay, well, perhaps if the appellate chooses to come back next year, they can provide better evidence, or if they choose to go to court because they have an issue with our judgment, then perhaps he can get some relief in the courts. But I think that we're dealing with a one or the other instance here of the town's value versus the appellant's opinion of value. All right, so the time now is 9:04. We didn't make as much headway as we were hoping to, but we did have some good discussions earlier. Alexis, you have your hand up?
I would say I'm happy to make myself available later this week just to go through the beach area.
That would be.
Kathleen, yeah, I'll connect with you via email.
That would be tremendous.
This is Kathleen. I do have Alexis tomorrow night, right? You're on tomorrow night too?
Yes, and I can be available on Thursday as well.
On Thursday. Okay. And Peter, you're Wednesday and Thursday. Yeah.
Right. And to, I will do my best to, see if I can get on at some point tomorrow night, if that's helpful. Yeah, right now I'm not sure I'm going to be in for tomorrow night.
Okay. As you can see, every half hour we can get is valuable to us, given the fact that it is already the 19th of April and we owe it to the town and to our board to complete our work as efficiently and as expeditiously as possible. So I thank you all. Does anyone want to call an end to this meeting?
A motion to adjourn.
I'll second.
Okay, we have a second. Thank you very much, everyone, for participating this evening. See you tomorrow night.
Thank you, Harold.
Thank you.
Good night.
Good night.
Good night.